May I please, my lord?
Yes.
My lord, I beg to mention item number 16, my lord.
Item 16.
Yes, my lord.
Yes.
My lord, the CD was called for, my lord, but then since there was not a fixed date, my lord, it was just 3 weeks, my lord. I could not call for the CD, my lord. So may I humbly pray, my lord, can the matter be fixed on 11th, my lord, a fixed date, my lord, so that I can call for the CD, my lord.
Who is for the petitioner?
Petitioner.
Informed.
No, my lord, I'm unable to reach the petitioner.
Okay, you want this matter to be fixed on 11th?
11, my lord. It's a anticipatory bail application, my lord. Bail has been already granted,
It was
my lord.
protected.
Yes, my lord.
Okay. Mr. Opada, Plan Standing Counsel. It's SIC,
ACB, my lord.
ACB. You get it changed?
My lord.
ACB. Submitted. And then the place for some more time to some more time for production of CD. Stop. As prayed for, comma, let this matter be listed on 11th.
11th, my lord.
11. Okay.
Obliged, my lord.
My lordship, I beg to mention item number 33.
33.
Yes. This matter may be fixed for another day.
Yes. What is this matter? You are for?
Affluent on behalf of T. Tapak.
Okay. Have you informed the other side?
Yes.
my lord.
Okay. Mr.
B. Sibo.
Sibo, Land Counsel for the applicant prays for adjournment of the matter for 2 weeks,
Yes.
to which Mr. L. Parmes, Land Counsel for the respondent, has no objection. Prayer allowed. List this matter after 2 weeks.
May I submit?
Yes.
I beg to mention item 11, my lord. 11, my lord.
Yes.
Here, my lord, I am for respondent, my lord. I am yet to file affidavit in opposition in this case, my lord.
Not yet filed.
My lord. I have informed the other side, my lord. I am praying for the listing of matter after 3 weeks, my lord.
Okay. Not yet filed.
Not yet filed, my lord.
Mr. L. Parme, Land Counsel. You are for? Standing Counsel.
Yes, standing counsel, power department, my lord.
Okay. Land Standing Counsel for the Power Department. Pray for further 3 weeks' time to file counter affidavit. He has also informed and obtained consent from the Land Counsel for the appellant. Stop. There, who is stated to have no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Obliged, my lord.
May I, Your Lordship? Lordship, I beg to mention item number 9, Your Lordship. This matter to be fixed on next week, Your Lordship. Item number 9, Your Lordship.
Yeah.
Next week, Your
My lord,
Lordship.
here I am for the petitioner, my lord. In fact, my lord, there is an urgency. However, my lord, next week, my lord, I'll be having personal difficulty. So, my
Okay.
lord, may I pray that my lord, matter may be listed on 17, my lord.
17.
Yes, my lord, for hearing, my lord. Pleadings
Okay.
are completed, my lord. Everything is, my lord.
On the prayer of the parties, let this matter be listed on 17/11.
My lord,
Okay.
for
And-
hearing, my lord.
This is for hearing.
My lord, it is admission hearing, my lord. But it's
Admission here.
Pleadings complete.
complete.
So matter to be listed for hearing.
Yes, my lord.
Okay, Your Lordship.
Have you filed affidavit?
Yes.
Yes, Your Lordship.
Okay. Both Mr. Matukato, Land Counsel for the petitioner, and Ms. P. Pango, Land Government Advocate, are present and submits that the pleadings are complete and the matter is ready for hearing. So, let's pray for Kama. Let this matter be listed for hearing on 17.
My lord.
Okay.
Your Lordship. And Your Lordship, also item number 38, Your Lordship. 38, this matter to be listed on 18th of 11, Your Lordship, 18th of this month.
38.
38, Your Lordship.
Yes.
Hearing. This matter to be listed on 18th of November, Your Lordship.
18.
Yes, Your Lordship.
Have you informed the other side?
Yes, Your Lordship.
Ms. P. Pango, Planet counsel appearing on behalf of the state respondent with the consent of the learned counsel for the appellant. Praise for listing this matter on
18th,
18th.
18th, 11,
1811.
2025.
The prayer is allowed. List this matter on 18 accordingly. Okay.
Oblige, your lordship.
My lordship, mention for hearing. It is, this case is for hard matter. On, listing on 10/11.
Part hard.
Yes, lordship.
What is this matter about?
Appeal.
What appeal? Criminal.
Civil appeal.
It's a part hard matter.
Yes, lordship.
Okay.
Or
You want this matter to be listed on
10/11, Monday, next Monday.
next
Coming
Monday?
Monday. Thus 10.
Part hard by this court.
Yes, lordship.
Or this court will not, this court will not sit on Monday.
Maybe another date.
Six week.
What is this matter about? This court will see, is sitting this week only, and thereafter, of course, last part. Okay, December first week.
December first week.
Hmm?
No, it's urgency. Senior was instruct me, fix this matter on 10th November.
10th November.
Yes.
If it is a part hard, 10 November, this court will not be available.
Okay. Then,
Then next, this court will be available on during the first week of December.
okay, I am,
Okay, get listed. Okay.
May I, your lordship?
Hmm.
Plus, again, I wish to mention item number 4 and 5, your lordship. This matter may be listed after 6 weeks, your lordship, as instructed by.
Additional affidavit not yet filed. By whom? Item 4.
Item 4,
Who is for the petitioner?
petitioner, your lordship, taken concern, your lordship. From petitioner,
You
your
have
lordship.
taken
we have-
consent?
Yes, your lordship.
Okay, Miss Pango, huh? P. Pango. Learned counsel appearing on behalf of the state respondent with the consent of the learned counsel for the petition. Prays for
6 weeks, your lordship.
adjournment of the matter for 6 weeks. The prayer is allowed. List this matter after 6 weeks.
Oblige, your lordship.
May I please,
Order 5.
My lordship.
Yeah.
My lordship, I wish to mention item number 7. On behalf of Tito Pu, the leading counsel, and as he is out of station due to ill health, so lordship, this matter maybe fixed after 2 weeks. We will inform the other party also. We are petitioner.
Yeah, for the petitioner.
Yes,
Have
lordship.
you informed the other side?
Yes, yes.
Okay. Mr.
Tita niya.
Titanya, learned counsel submits that his senior, Mr. T. Topo, learned counsel for the petitioner, is out of station. Therefore, pray for adjournment of the matter. For how much?
2 weeks, after 2 weeks.
For 2 weeks. Okay, he has also obtained consent from the learned counsel of the other side. Stuff. He has prayed for Kama, list this matter after 2 weeks. The prayer is allowed, huh?
Oblige, my lord.
Okay.
May I please say, Lordship? Lordship,
Yes.
I beg to mention item number 32 of the order column, Your Lordship. In this, Your Lordship, we are appearing for the official respondents, and we are yet to receive our instructions, Your Lordship. Yeah, Your Lordship. May kindly grant 3 weeks' time, Your Lordship.
Who is for the?
I'm for the petitioner.
For the petitioner.
No objection.
No objection.
Okay, Miss P. Sangeeta, learned government advocate for the state respondent, submits that she is yet to receive an instruction to file affidavit in opposition. So, and prays for how much time?
3 weeks' time.
3 weeks time. To which Mr. Skijamo, oh sorry, E-Pai, learned counsel for the petitioner has no objection. Prayer allowed. List this matter after 3 weeks.
Obliged.
May I please, Lordship? Lordship, I beg to mention a pending criminal petition, Lordship. Lordship, kindly this matter may be listed on 10th of this month, Lordship.
Criminal petition.
Yes, Lordship. There's urgency since, Lordship, our endeavor is to dispose this matter before the next date of trial.
Criminal petition is can be mentioned before this court.
Lordship,
Okay.
Obliged.
Which item?
May I please, Your Lordship?
Lordship, I beg to mention for hearing another matters on 6/11/2025. It's a criminal
What is this? Criminal?
criminal petition, conviction under 376.
Okay.
May I please, Your Lordship? I beg to mention.
When you say 6/11?
6 November.
6 November.
Yes, Lord.
Today is
4.
what? This is criminal?
Yes.
Criminal appeal
Yes, Lord.
against?
Against convictions under 376.
Okay.
May I please, Your Lordship?
My lordship.
I beg to mention item 39, my lord.
Item?
39. We are supposed to file the status report, my lord, so we are not able to file. It requires 2 weeks' time, my lord, to file the status report of the project.
You have not yet, you are for respondent.
Respondent number 3, my lord. I have informed the petitioners also, my lord.
Okay. What is your submission, you said?
My lord, we are supposed to file the status report of the project, construction of the project, but we could not file, so it requires 2 weeks' time, my lord, to file that.
Status report was to file by you.
Yes, my
Supposed to
lord.
be.
Yes, my lord.
Okay, you are Mr.
T. Marangar,
Planning Council for the respondent number 3.
respondent number 3, my lord.
Submit that. And then praise for Father 3. How much time you
2
said?
weeks' time, my lord.
2 weeks
Request
time,
it can be
file
filed on the
status.
28th of this month, my lord, the matter.
Okay, that's Mr. So-and-so submits that the respondent was directed to file a status report of the project. However, due to some personal difficulties, the same could not be filed, and therefore he prays for Father 3. Father, how much? 2 weeks
2
time.
weeks, 2 weeks' time, my lord.
2 weeks time. Stop. The Learning Council Father submits that he has also obtained a consent from the Learning Council for the petitioner. Stop. In view of the above, the prayer is allowed. List this matter after 2 weeks.
My
Okay.
lord, it can be on the 28th of this month. 28.
Okay. In view of the above, and as prayed for by the Learning Council for the respondent, let this matter be listed on 28 November. Okay.
Highly obliged, my lord.
Lordship, I beg to mention for one civil revision petition for withdrawal. The matter may be listed for tomorrow. Deeply.
Item number 1.
May I please, Lordship?
Yes.
Lordship, this is a joint application filed under Section 520 of the BNSS Act, BNS 2023, Lordship, trying for causing of the SAPA WPS case number 1322 under Section 498A/323 of IPC, Lordship.
498A.
Yes, Lordships. Now, Lordship, the brief facts of the case is that, Lordship, petition number 2 is the complainant, Lordships, and wife of petition number 1, Lordships, and they have 3 children, Lordships. Due to some differences crop up between the husband and wife, Lordships, due to extramarital affairs of the husband. Because of that reasons, Lordships, the complaint was lodged, Lordship. Complaint was lodged on 17/8/2022, Lordships. Complaint letter is at Lordships Annexure 1.
Okay, now where the case is pending?
Now, Lordship, case is pending before learned CGM SAPA, Lordships.
Charge is already filed.
Charge is already filed, Lordships.
Okay. What is the stage of the trial?
Stage as evidence, Lordships.
Evidence already recorded?
Not yet, Lordships.
Not yet.
Yes. Now, both husband and wife.
2022.
Yes, Lordship.
Evidence not yet recorded.
Not yet.
Charge framed?
Charge already framed, Lordships.
When the charge was framed?
Charge was framed on Lordship
29/6/2023, Lordship.
Yes, Lordship.
23, Lordship.
23. And
Yes.
there's no evidence.
Lordship, no, he didn't annex anything.
Anything.
Lordship.
We'll call for the record then.
Yes, Lordship.
Lordship, here both the parties, husband and wives, enter into the agreement, Lordships.
Maybe.
And now they are living peacefully, Lordships.
Okay.
So,
Mr.
T Dada, Lordship. One more prayer, Lordship. My responsive submission is during the pending of disposal of this case,
No,
Lordship.
we do not know the status. You are not in a position to tell the status. No. Why you did not annex the last order?
Last order is at page number, Lordship.
Where?
Annexure 3, page number 51, Lordships.
No, this is just the last order, Lordship.
Where,
Last order.
yes, Lordship. Where the learned CGMs frame the charge, Lordships. And during the pendency of
This
trial,
is the last order.
This cannot be,
23.
Lordship.
Hmm?
This cannot be last order, Lordship.
this is the order
When
where
next date was fixed in by this order.
Next date fixed on Lordship 2/8/2023, Lordship. 2023, Lordship.
For prosecution evidence.
Yes.
yes, Lordship. Both the parties had entered into the compromise, Lordship. Now both are living
Maybe,
peacefully,
maybe. If
Lordships.
We have to see the trial. Okay.
So this is completely
Mr.
T Dada, Lordships.
Your name T.
Dada, Lordships.
Why your name is not being reflected in the course list?
That I don't know, Lordship. I have given my name to the register, Lordships. But Waklanam I have filed, Lordships.
Council name is there. Either the
Yes, Lordship.
Lana counsel for the petitioner. This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, seeking quashing of the. Where have you mentioned the case number? GR case? Okay. Quashing of the proceeding of GR case number 69/2022 arising out of SEPA Women PS case number 13.
13, Lordships.
2020/2022 under section 498A/323 of the Indian Penal Code. Pending before the Chief Judicial Magistrate, SEPA, Startup. Call for the scanned copy of the case record. Issue notice. Since Mr. Lorry, Lana PP accept notice for PP accepted notice on behalf of the state respondent. No formal notice need be issued. Staff, list this matter. Have you received the copy?
Yes, Lordship.
Okay, list the matter. When?
After 2 weeks, Lordship.
After 2 weeks?
Yes, Lordship.
Okay.
After 3 weeks, Lordship.
3 weeks.
After 3 weeks.
Lordship, entry may be Lordship granted, Lordship. Proceedings may be suspended, Lordship, till further order, Lordship.
Mr. Dada Lana counsel for the petitioner submits that the case and after framing of charge against accused petitioner number 1, petitioner number 2, 1 or 2? Who is
One.
accused?
Accused 2, Lordship. Lordship 1, sorry.
No, 1.
Yes, Lordship.
The case has not proceeded for framing of charge against the accused on 29/6/2023. The case has not proceeded for further trial thereafter. We further submit that the petitioner number 1 and 2 being the wife and husband are staying together. No. Wife and husband has amicably settled the matter. When it was settled?
It was on Lordship 22/10/2025 at page number 53 to 55, Lordship.
Settled, no? Amicably settled the
Register at the notary office, Lordship.
dispute. They amicably resolved the dispute, between them, and now they are staying together as wife and husband. Therefore, pray for an interim order. Stop, Para. In view of the above, the proceeding of the GR case number 69/2022 shall remain stayed till the next date of listing. Okay.
Highly obliged.
Item number 2.
May I please, Your Lordship? Your Lordship, this is a criminal petition filed under section 528 of the BNS 2023, Your Lordship, seeking for quashing the criminal proceeding arising out of Papu Hill PS case number 37 of 2024, Your Lordship. Currently registered under section 115 and section 85 of BNS, Your Lordship. Currently, Your Lordship, the case is pending before the Honorable CGM UPI, Your Lordship, and at the stage of consideration of charge, Your Lordship. Here in this case, Your Lordship, the brief of the fact is that, Your Lordship, the petition number
What is this 115
115 is voluntary causing harm, Your Lordship.
and 85?
Husband and relative of husband of a woman subjected.
Which one is non-bailable?
85, Your Lordship.
When the FIR was, where is the FIR?
Your Lordship, kindly come to the page number 29, Your Lordship. May I read the FIR, Your Lordship? On 21/07/20.
Wife and husband.
Yes. On 21/07/2024, I was assaulted by my husband Sri Techi Natung in our residence at Lower Borong village.
Now pending before which court you said?
CGM UPIA.
UPIA. 24. What is stage?
CC, Your Lordship.
Charge framed, not yet.
Oh, not yet, Your Lordship.
When it was, when charge sheet was submitted?
Charge sheet was submitted on 16/10/2024.
24.
Yes, Your Lordship.
Charge not yet framed.
Yes, Your Lordship. Your Lordship, the present case is a purely matrimonial case, Your Lordship, arising out of.
Okay. Pardon, Mr.
Tigame, Your Lordship.
To call for the record.
Yes, Lordship, but difficult is the.
Where is the case number?
Yes, there is no GR case number, Lordship.
How do we call? Which case is to be called for then? Which case record is to be called for? You said it is pending before the Chief Judicial Magistrate.
GD number is given, Your
Where is the
Lordship,
case
04010924.
Where do we find? Where have you stated the GD number? Where is the last order? Any order passed?
I have not annexed the copy of order,
Why?
Your Lordship.
Why? Is that secret?
No, Your Lordship.
Okay,
I think
then.
it's not required.
Where is the case number?
Lordship, it appeared to be the GD entry of Lordship.
GD entry?
Yes, Lordship, page
How do
number
we go?
29 at the top, Lordship.
No. Which case is to be stayed?
Lordship, through e-court, Lordship, I have seen the GR number.
It's to be called for, huh?
Through e-court, Your Lordship, I have seen the GR number.
Oh, learned counsel, GR number.
Yes,
Okay, you have seen it.
yes.
And then,
Yeah.
and then what happened? What you have achieved? Yes, it is understood. You have seen. Then what happened? Where is the number?
I have not placed in my petition, Your Lordship.
Hmm? Where?
GR number is not placed in my petition, Your Lordship.
Okay, then record which case is to be called for. Cannot. You have to incorporate.
But Your Lordship, I have know the GR number, Your Lordship. But
Okay.
it was not.
But I don't believe it.
Then Your Lordship may kindly fix tomorrow, Your Lordship. I will
Those
amend
are the
some-
basic thing. Because your prayer is to call for the record. Which record? Okay. And to stay. Which is to stay. As prayed for by the learned counsel for the petitioner. Tomorrow what you'll do?
Tomorrow is holiday.
In holiday? During
day,
holiday.
day after tomorrow. You know.
Okay, day after tomorrow, what you'll do?
I will amend the paragraph, Your Lordship, and
And-
if possible, Your
and-
Lordship, one order, last order, I will be
Then you
enclose
withdraw,
it.
better withdraw and file it again.
Okay.
Mr. So-and-so, learned counsel for the people, because later your prayer also not yet incorporated. Those numbers. Mr.
ठीक है मैं Your Lordship.
Learned counsel for the petitioner wants to withdraw this criminal petition with liberty to file afresh after making necessary correction. The prayer is allowed. This criminal petition is dismissed as withdrawn. Okay.
Obliged.
On with liberty as prayed for. Okay. Obliged.
Item number 3.
My lord, by this writ petition, my lord, I have a very limited prayer, my lord. And this prayer number 3 may be kindly considered, and this respondent number 2 may be directed to dispose of my representation, man.
What is this case about? Otherwise,
Yeah, my lord, this is a illegal appointment, my lord.
illegal appointment.
Yes, ma'am. In the forest department at Simpu, my lord, 14 vacancies were there on superannuation of various MTS, my lord. So these petitioners, 10 in numbers, they applied through their legislators, and their case was forwarded by the PCCF to the director to consider in accordance with law, my lord. But without following any due process of law, my lord, these 14 private respondents, they have been appointed without any interview, my lord.
Okay.
Even walk-in interview.
So, but then how your case can be considered?
Yeah, because
You were also seeking appointment without interview only.
my lord, we prayed for conduct of interview in accordance with law, my lord. So although there is no hard and fast recruitment rule in regards to appointment of contingency staff, my lord, there is a guidelines, my lord, which says that, my lord, due process of law has to be followed, my lord.
Okay, you're challenging their appointment also.
Yes, ma'am.
Will the direction to dispose of your representation will solve the problem?
Yes, my lord, because we have sought
Now, in
for,
that case, the appointment will not go. Their appointment already appointed.
yes,
Your contention is that they were illegally appointed without any interview, without following due process.
yes, ma'am.
That will not go. If we direct the authority to dispose of your representation, their appointment will not go automatically.
My lord, in our representation, we have sought for cancellation of the appointment even, my lord. So only after this representation is disposed of, my lord, we may have a strong case, my lord.
Okay,
Because
this is ground. You are preparing for ground. That means
We have already, Lordship, made some
Yes.
grounds, my lord, which are not
Lordship,
satisfactory.
At this stage, notice may be issued because there are private parties also, Your Worship. And moreover, the petitioners, they have not come with a clean hand themselves. The representation also, Your Worship, they are represent.
Now what he is submitting at bar is that to direct to dispose of his representation only.
Represent.
He is no longer challenging the illegal appointment. And it says content. He'll be contented, I think, because he has made prayer before the authority to cancel their appointment also.
Yes, Lord.
I don't know, he has some other plan.
May I take you to the page number 39 of the annexure, Your Worship?
Yes.
The last paragraph, the representation, where the prayer is, in this regard, we ardently, so the last paragraph, we solicit your esteemed self to kindly issue a necessary direction for immediate cancellation of appointment, 14 contingency staff. They have, Your Lordship, because they have already been appointed, Your Lordship, in the month of April. And if this is considered now at this stage, also it will not be just and in the due procedure. They should be heard, Your Lordship.
No. Only to direct the authority to dispose of the representation submitted by the petitioner would not adversely affect the respondent, because it will now be a responsible for on the part of the authority concerned to dispose of whether he gives opportunity to the other side or not. It depends on him.
Because, my lord, in the representation, we have ventilated all our grievances, my lord.
And also they have added, and to appoint us as contingency workers on the basis of recommendation made by our respective legislators and subsequent forwarding by the conservator of forest, Your Lordship. This is their prayer, Your Lordship. They are not asking for just and fair selection process, Your Lordship.
Because, my lord, rightly or wrongly, the department competent authority have taken cognizance of our representation and independency of our application, my lord. This private respondents has been appointed, my lord, on pick and choose basis only, without conducting any interview, my lord.
And they want to pick them for the selection, Your Lordship, for the appointment, Lord. Notice.
May I read the relevant guidelines, my lord?
Yes, where?
As page 37, my lord. Page 37. Paragraph 3 is the relevant portion, my lord. In point number 2, our category falls under, my lord. In respect of point number 2, above, as of now, there is no procedure or guidelines for engagement, appointment of contingent, casual employees. This does not mean that the engagement, appointment of contingent staffs, casual workers are taken on pick and choose basis, which will attract Article 14, 15, and 16 of the Constitution of India. On creation of contingent casual force or on occurrence of contingent casual force, the appointing authority shall advertise the post and select the candidates on the basis of their performance and merit in the written test through a departmental selection committee through the common examination scheme notified in the year 2006, my lord. So even these guidelines has not been followed, my lord. Without even a walk-in interview, this 14 private respondents has been appointed.
Despite these guidelines, why you want that only direction to dispose of your representation?
Yes.
You have a case in this case.
That is why, Lordship, notice may be issued at this stage.
My lord, because our earlier representation, on the basis of our representation, my lord.
You have a different source.
No, my lord. On the basis of our earlier application, my lord, this page number 29, my lord, the PCCF has directed the director, my lord, to consider our case on as per law, my lord. In this regard, I am directed to request you to take
Where are you reading? Page?
Page 29, my lord. This is a letter issued by the PCCF to the subordinate officer, my lord, that is DFO, my lord, whereby he has mentioned forwarding of UO note regarding a reference UO note so and so that so and so. Enclosed, please find here with a copy of UO note received from Sri G.K. Tako, Honorable MLA, Tali Assembly Constituency regarding appointment of Ms. Danayani in place of Srimati Prabha Chakraborty. In this regard, I am directed to request you to take action at your level as per rule and regulations in such cases. So instead of acting, my lord, and complying with this, my lord, in pendency of this direction, even, my lord,
Now, I think the best would be, because if they were appointed without following the rules,
Yeah.
then the order will go and to direct for following the procedure.
Yes, my lord.
But
And
now, your prayer, if we grant, even if we grant your prayer, unless we have different way to get your job done, your appointment also will be challenged later on. It will not help you again. So what do you want? Still you want that your dispose of this matter with the direction to dispose of your representation?
yes, my lord, because we have sought the authority to.
Which representation? Representation.
Representation is at page 38, my lord. Or if at this stage, my lord, their appointment is interpreted with by this honorable court, my lord, then
No. Because you have also no right to claim on the basis of the recommendation of the MLAs.
okay, my lord, then the legality and validity of the basis of our representation may be allowed to be, my lord, disposed of by the authority, my lord. This our representation may be allowed to be disposed of on merit, my lord, as per law.
Or Mr. N. Pada, Land Council for the petitioner. I've also had P. Sangeeta, Land Council, a Land Government Advocate for the state respondent
1 to 4, Your Lordship.
1 to 4. By filing this writ petition under Article 226 of the Constitution of India, the petitioner challenged the appointment of private respondent number.
Lordship, private respondent number.
How many private respondents are there?
5 to, my lord,
5 to how
5
many?
to 18, my
18. Which post you said? Have you annexed their appointment?
Yes, my lord.
Where?
Next, their appointment is at page 34, my lord. A joint appointment order.
Okay, 34.
Yes, my lord.
Oh. This is engagement of contingent. Okay, challenge the 26. Challenge the challenge the order dated 25/3/2025 issued by the respondent number.
Respondent number 3, 3, my lord.
It's respondent number 3.
Yes.
It's 3, Your Lordship.
He is the State Forest Research Institute
Yes.
Director.
Yes.
Director.
Respondent number 3. By which 14 numbers, no, 14 persons have been engaged as contingency worker they are appointed in the where? Different place.
No, in the same office, my lord. Generally, they are commonly called as MTS, multitasking staff.
No. It's office of some Dirang, some Namsai, some
Yes,
PP,
yes, sir.
some Chesa. And posted them in a different place of Arunachal Pradesh. Staff, huh? The contention of the para, land council for the petitioner is that there is a, what is this called, guideline?
Yes, my lord, guidelines.
There is a procedure. A guideline issued by the government.
Issued by the Joint Secretary to the Government of Arunachal Pradesh. My
Okay. For the guideline for appointment for engagement of what is guideline is called?
For engagement of contingent of casual workers. My
Okay. Guideline for engagement of contingent stroke casual worker in a department issued by the Joint Secretary to the Government of Arunachal Pradesh on 25/4/2025. Wherein it is provided that on creation of contingent stroke casual post or on occurrence of contingent stroke casual post, comma, the appointing authority shall advertise the post and select the candidates on the basis of their performance and merit in the written test through a departmental selection committee through the common examination scheme notified in the year 2006. What is this 2006?
This is also regarding, my lord, the appointment of casual workers.
Which also prescribed procedure for appointment of the casual worker staff. Para. However, at this stage, the land council submit that this is not pressing for the other prayer made in the writ petition. And his limited prayer at this stage is that to the, and some is that the petitioners has submitted a joint representation against the appointment of 14 contingent staff by the respondent authority on respondent authority on 8/9/2025. And therefore the said and therefore pray that this writ petition may be disposed of by directing the respondent authority to dispose of the said representation dated 8/9/2025 submitted by the petitioner before the it was before the principal chief conservator.
Yes, my lord. Respondent number 2.
Okay, then it will be corrected. The before the respondent number 2, principal chief conservator of forest, within bracket PCCF staff. Then dispose of with the direction to dispose of the representation, probably have no objection. It will be only dispose of the representation only. No, we will not give any direction.
Yes, Your Lordship.
Okay. The Land Council for the respondent, the land government advocate for the state respondent, submits that to the extent of disposing of, and the he has no objection if the direction is only to the extent of disposing of, to the extent of directing the respondent authority to dispose of the representation submitted by the petitioner staff of Sarah in view of the above, and as prayed for, this writ petition is disposed of at the motion stage with the direction to the respondent number 2 to dispose of to consider that to dispose of the representation dated 8/9/2025 submitted by the writ petitioner against the appointment of 14 contingency staff appointed by the respondent number 3. Within a period of 30 days. Yes, 30 days.
30 days, Your Lordship.
Okay, within a period of 30 days from the date of receipt of the certified copy of this order. Okay. With the above, this writ petition stands disposed of. Okay.
Most of
Item number 6.
Fellowship.
Yes. You were to file rejoinder.
हम सर कर रहे हैं ना नहीं
Rejoinder not yet filed.
Not yet filed, Your Honor.
So
Lordship,
the authority have complied with the direction of the court earlier. They have already done the survey and they included the name of the petitioners in the draft list.
Okay, then,
That is the recent development of the case.
okay, then in that case,
My humble prayer is that they have included the entire petitioners in the draft list, but the question is that they have not verified the value of the land yet, and they have only included the amount, the quantum of the property of the standing crops and all the properties, not the land.
no, what do you want?
Your Honor, I want a direction that as the land is purely belong to the scheduled area, the measurement of the land should be included in the compensation, Your Honor.
Now you say that your part prayer has been complied.
Yes, Your Honor.
Okay. Not fully.
Lordship, yes. There was the issue, Lordship. Issue was that in the stretch of the Vijayanagar Road, there are few settlers, non-APSTs. And there is land issues between the actual landowners and the APST, non-APST settlers. Therefore, the district administration has decided that only the valuation of the property will be awarded, not the land value. It has been kept in the stake and further direction is
Now it
required.
appears that there has been subsequent development. You bring down those subsequent development into on record, we'll dispose of accordingly.
Okay,
Okay, by way of filing rejoinder.
okay.
Okay. Mr.
Hitatak.
Learned Counsel for the petition of praise for further, how much time will require?
Within Your Lordship, within a week or 2 weeks.
Further 2 weeks time
2
to
weeks.
file a rejoinder to the affidavit filed by the respondent staff. The prayer is a prayer not objected to by Ms. Pangu, learned government advocate for the state respondent. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Most obliged.
Item number 8.
Yes.
May it please, Your Lordship. Lordship, as per dated 28 October, direction was given by this Honorable Court to the additional PP to take the impression from the session court whether as to why the examination of alleged victim has not been conducted till this date.
Oh, what was the age of the victim?
During the incident, Your Lordship, it was 17 years and
Where do we find any record anywhere?
no, Lordship. There is an ossification. Almost at only 2 months was left as per the.
What was the last order?
28/10/25.
What is the latest status? Whether the victim has already been examined by now? Lana PP? Additional PP. Whether the victim
Sorry,
has
Your
been
Lordship,
examined?
I have no idea because
No idea.
on last occasion, some other PP appeared before this court.
Okay. You were to obtain instruction.
Yes.
Public prosecution may impose such in the trial court.
Okay.
Okay, what was the age of, do you have any, or on record, is there anywhere on record reflecting the age of the victim? What was the age of the victim at the time of occurrence? As per her statement, she was 17. Any Aadhaar card seized by the police showing her age? Because it appears that if she was major at the time of occurrence, it appears that there was a consent.
Yes, no, in
3 weeks. Okay. You'll say the learned counsel for the respondents, huh? Not respondent number 1 only. Okay.
Item number 13.
May I please, Your Lordship?
Yes.
Your Lordship, this is a bail application, Your Lordship.
Mm.
Your Lordship, accused was arrested under section 21B, 27A, and 29 of NDPS Act. Your Lordship, so far he has spent 7 months in the judicial custody. The charge sheet has been filed. Your Lordship, investigation has completed, and Your Lordship, during the CC hearing, 2 sections, section 27A and 29 of the NDPS Act has been dropped. Only section 21B is framed against the accused person.
Charge framed.
Charge framed, Your Lordship. Your Lordship, may come
What section you said? 21B.
21B, only 21B.
Okay. What is the punishment?
Punishment 10 years, Your Lordship.
Okay. Fine 1 lakhs plus.
1. Your Lordship may come to.
What is the stage of
Your Lordship, next
trial after framing charge? Any evidence recorded?
Not recorded yet.
Not yet.
Not yet.
When the charge was framed?
Charge were framed on 13/8/2025.
13/8.
13/8.
Okay, recently only?
Yeah, recently.
Okay, what is the next date fixed for?
Next date fixed for 14/11/2025.
14/11 for evidence of the prosecution witnesses.
Yes, Your Lordship.
Okay.
Your Lordship may come to FIR, Your Lordship.
Earlier your bail was rejected.
Rejected by the session court, special judge.
Now also the special judge where the trial is going on would be the best person to consider your case, your bail, whether granting bail, whether you can be granted bail or not. Petitioner is, who is the petitioner?
Petitioner is the mother of the accused person.
Okay.
Deep Mala.
Accused is otherwise male.
Yes.
Vicky Chetri.
Vicky Chetri. Your Lordship, as far the FIR, recovery was. Recovery is.
See, just now, see, there was a 21 as per FIR and registered section is 21, 27 and 29 NDPS. But then now you say that the charge framed only under section 21.
Yes.
Now, having found prima facie case, material found against you for commission of offense under 21B.
Yes.
The charge was framed. That is now there.
Yes, Your Lordship.
27, 29, we are not concerned with now. But now since the trial has begun, how do we consider? So,
Your Lordship, the case is accused has a very strong case, Your Lordship. After the framing of charge, the bail has been rejected. Now, Your Lordship.
That is why I'm saying.
Yes, Your Lordship.
After framing of charge, if the bail was rejected, after consideration of the entire matter on merit,
yes, Your Lordship,
the bail was rejected. What is the new ground you have taken this time here?
Your Lordship, there is a new ground, Your Lordship, because Your Lordship earlier.
Thereafter, what subsequent development took place? It was considered on merit. The trial court has considered.
Yes.
Your bail application on merit and dispose of on merit.
No, Your Lordship, only on Your Lordship, the observation while rejecting the application, the trial court has observed that there is a prima facie case. No, Your Lordship, merit of the case was considered. Your Lordship,
No, merit, entire merit, detail will not be considered.
yes.
Only only the trial court, if he has found prima facie material against you for commission of the alleged offense, then it was rejected. Now it is under trial. If there is any new, no new development thereafter, subsequent development thereafter, after rejection of bail, under what circumstances or on what basis this court will consider your bail? What is to be appreciated? What new thing is to be appreciated? Because that was already appreciated after considering your bail or bail submission.
Yes, Lordship, even while filing this bail application, petitioner did not annex the bail application or rejection order, Lordship.
Did not annex.
No, in
Your
the-
Lordship,
I
that
haven't
was
seen.
apprised
Then
before the
that
court.
you should have.
Your Lordship,
also-
that was apprised before the court because after the lapse of 2 months, the bail order was not prepared. Therefore, Your Lordship, we have approached before this court without bail order.
On the record, it must be available.
Yes, Your Lordship.
Lordship.
When a charge was framed?
Charge was framed on 13/8/2025.
13/8.
13/8.
See, he has perused the charge sheet, statement of the witnesses, seizure memo, FSL report, which came positive and after relevant material. So after perusing entire records
Yes, Lordship.
and the trial court found material, incriminating material against you.
Your Lordship, this material, what has been recovered from my possession was not recovered from me. It was recovered from a public toilet. Your Lordship, which can be accessed by a multiple person. There is no causing evidence that directly shows that those seized material belongs to me. Only on suspicious I have been arrested. Your Lordship, statement of the witnesses are very clear.
Who are these Kantatacha and Taturonya? Are they the eyewitness or the
They are
teacher-
IO.
teacher witness?
They are IO. No one here, no one is eyewitness here.
It'll fine. It'll be fine. Because if they are examined, if they could not, or if they fail to show that it was recovered from you, if there was any doubt, then you will be entitled for bail. But then unless certain circumstances changes subsequently, it will be difficult for this court to grant on the same ground.
Yes.
Because there is a material till now, there is a material against you.
Your Lordship, I'm saying,
On what basis?
no,
you will be-
my new ground is, Your Lordship,
Bail was rejected on when? When the bail was rejected?
bail was rejected on the same day.
On that day?
Yes, Your Lordship.
That was when? 13. When you said?
13.
13/8.
13/8.
No.
No, Lordship, as per his statement in para 3, Lordship, 24, Lordship, 24/8/2025, Lordship. Page number 3, para 3, Lordship.
Of?
In his petition.
Petition.
application,
What,
Lordship.
what is that?
Page number 3, Lordship.
What is that?
He says on the same day bail was rejected, Lordship, while when charge was framed. Lordship.
Yeah, that is
But-
what I'm trying to find out. See, learned PP, you should have actually seen this record and then flagged the important document.
Yes, this
relevant document.
Yes, I try to, but Lordship,
You see,
due to the positive time.
just now produce the record, you want the court to find out entire thing, is wastage of time.
Yes, Lordship.
You have received this earlier,
No, Lordship, this morning only.
this morning only, but then still then.
I tried, but due to the positive time, Lordship could not mark all, Lordship.
See, we should remember our own duty.
Yes.
Unless you perform your own duty, it will be difficult for the court to perform your duty as well. So many things have recovered.
Your Lordship, come to the statement of the witness.
Just a minute, I'm looking at the inventory, yeah. So many things. Case amount also. How many persons were arrested in connection with this case?
Only I was arrested.
See, so many things from there.
Your Lordship, come to the judicial order passed by the judicial magistrate.
What is that?
Page number 38.
Okay, what is that?
Your Lordship, when the seized item was produced before the judicial magistrate first class for sampling and weighing, only 7.4 gram was found. Therefore, Your Lordship, charge sheet has been filed against only 7.4 gram. But in the FIR, it has been stated that 44 gram was recovered. And you will see nowhere in the record it says that certain amount has been recovered from my possession. And you will see the witnesses and the complainant are giving different contradictory statement from one another.
Witness and?
Witness, complainant, informant.
Sure.
All of them are giving contradictory statement.
Maybe. That is also possible. Witness looking from that side. Then.
No, they are the witness. They are the person who found the contraband substance lying in the bathroom. Only on suspicious, Your Lordship, I was arrested. Your Lordship, before, without any inquiry, without any evidence, how it can be said that those.
Can you find out the bail order?
Yes.
It's not there, it appears.
Your Lordship, I may be allowed to apprise the fact. Your Lordship, on the very day, I went to the secretariat office for my official work. While I was heading toward the bathroom to attend the natural core, already the staff member was already gathered near the bathroom. As soon as I reached the bathroom, they apprehend me, put into the bathroom until
they knew it from the very beginning, and then because since long time they have been suspecting you.
Yes, Your Lordship. Only on suspicious. This
No,
case is only on
suspicious, and thereafter, after confirmation, it was done. It was only you. They found that it was only you who used to keep. And you used to sell. So under the circumstances, it's very difficult. Let us see the bail rejection order once. If there was, if he had made some observation, and if thereafter subsequent, what according to you, the subsequent development after rejection of your bail by the learned special judge?
Yes.
Is there any subsequent development thereafter? No.
Yes, Your Lordship.
But only the thing is that no evidence was recorded till date.
There is also one of the ground, and another ground is, Your Lordship, he is the only son in the family. His father is currently undergoing a medical treatment.
That is different. That is different.
Yes.
That is different.
And Your Lordship, ground of arrest has also been not communicated properly, Your Lordship.
What?
Ground of arrest, Your Lordship.
Hmm.
He was there, Your Lordship. The police came apprehend him. That's all, Your Lordship. Nothing, Your Lordship.
Your challenge is on that ground?
Yes, Your Lordship.
Ms. Loy, I think that is not available.
So this is my second time, Lordship. I tried to find the bail order.
So it's not there, what I found. So you should have actually informed. Then I would like, this court would like to see the bail rejection order. What was the observation of the court? And then unless there is a, of course, new development thereafter, subsequent development after rejection, and if the court has appreciated all those, your submission, so I think it will be a little difficult. Can you, day after tomorrow?
Day after tomorrow, Lordship, I will.
Just bail order, I think the rest are there. And then if there is a letter status, new development thereafter, anything, any other, or any witness recorded, okay. Mr.
M. Contempt.
Lana counsel for the petitioner is present. Mr. Lloyd, Lana PP for the state submitted, although the trial court record, a scanned copy of the trial court record has been received. How it is incomplete, as the bail rejection order is also not on record. So, in view of the above, he prays for some time to produce the detailed the entire record, a scanned copy of the entire records, including the bail rejection order. The prayer is allowed. This is matter. Day after tomorrow.
Day after tomorrow.
Also.
Oblige, Your Lordship.
Item number 14.
May I, my lord?
Yes.
My lord, before going the factual metrics and pressing on the merit, while pendency of this adjudication of this bail application, my right to default bail accrued. So yesterday the court's observation was, only thing to ascertain was whether charge sheet has been filed or not. If not, then I am entitled to be released on bail on default. 90 days already elapsed by 29th of the last month.
What is the allegation against you?
Allegation is, my lord, trafficking of four-wheelers, illegal trafficking of four-wheelers in capital area, ICR. I'm just a private driver.
Have we received the case diary? Have you?
Yes, sir. Yes.
Okay,
yes.
what it says?
It's an organized crime syndicate.
Organized. When?
It's a number of people were arrested. Almost 11 people were arrested in this regard, in this case.
No, just a minute. Huh?
Yes, he was arrested on 37/2025. 37. July.
July 30.
Now it's
What is the maximum?
September, October 30.
90 days.
No, this is gone.
Where the
Charge
charge
is not yet filed. CD
Then in that case, he is entitled
default
default
bail.
You filed small application.
I have filed.
When?
Yesterday, but this morning. But my lord, even if I don't file by verbal submission also, it will suffice. I have the judgment of Supreme Court. I have filed, but just for.
Since you have already filed, let it come along with it.
Even if it's not come, this court
Then
has
what
the
will-
power. At phase number 23, 22, I have flagged it for my lord.
You have filed today.
Yes, morning. Page? 23, I have flagged it for my lord. Paragraph 27. In a fairly recent judgment reported as Rakesh Kumar Pal versus State of Assam 2017, so and so, a three-judge bench of the court referred to the earlier decisions of the court and went one step further. It was held by the majority judgment of Majan B. Law Court Justice and Deepak Gupta Justice that even an oral application for grant of default bail would suffice, and so long as such application is made before the charge sheet is filed by the police, default bail must be granted. These are the That you have to be make before the trial court. no, even in because this is filed under as a regular court That under is why section you 483. have filed this bail application before the High Court.
Yes, under
And then
483.
thereafter, on expiry of the statutory period of 90 days, 60 days.
No, before
as the case
expiry,
may be.
but during pendency, it's default accrued. The right accrued.
So that is why you have filed subsequently, you have filed on expiry of the statutory period. You have already filed one IA, isn't it?
Yes.
Apprising this court that statutory period elapsed.
Yes.
So had it been in before the trial court, would have been, of course. But since it is before the High Court, let us take up that. Okay, afternoon, if it is possible, today itself. If not, then just ask if it is ready. Hello?
My lord.
If the IA file today, if it is ready, produce it.
Yes, I have already sent.
Sent, no? Okay.
Yes.
Let us wait for some time.
But
Okay.
my lord, what my submit is even if for oral submission also, it will
Oral
suffice.
submission before the trial court, it appears.
No, before also High Court.
Hmm.
It's preceding paragraph, it's
Before High
cleared.
Court, before High Court.
Yes, it's in preceding paragraph, it's cleared.
Hmm.
Especially when for application is filed under 483. Because my application is under 483.
Your application is under?
483 as a regular bail.
Okay, where do I find that?
In my bail application,
No, where it says that it can be filed, the verbal submission before the High Court.
paragraph 27, my lord, what I have just read. Thereafter, as per 23, procedure for obtaining default bail. Paragraph 40.
Paragraph 40?
Yes, 40. Then
Yes.
45.
Where is that?
In the present case, it was also argued by the learned counsel for the state that the petitioner did not apply for the default bail on or after so and so, on which date his indefeasible right got extinguished on the filing of the charge sheet. Strictly speaking, this is correct since the petitioner applied for the regular bail on so and so in the Guwahati High Court. He made no specific application for grant of default bail. However, the application for regular bail filed by the accused on so and so did advert to the statutory period for filing a charge sheet having expired, and that perhaps no charge sheet had in fact been filed. In any event, this issue was argued by the learned counsel for the petitioner in High Court, and it was considered but not accepted by the High Court. The High Court did not reject the submission on the ground of maintainability but on merits. Therefore, it is not as if the petitioner did not make any application for default bail. Such an application was definitely made, if not in writing, then at least orally before the High Court. In our opinion, in matter of personal liberty, we cannot and should not be too technical and must lean in favor of personal liberty. Consequently, whether the accused makes a written application for default bail or an oral application for a default bail is of no consequence. The court concerned must deal with such an application by considering the statutory requirements, namely whether the statutory period for the filing a charge sheet or challenge has expired, whether the charge sheet or challenge has been filed, and whether the accused is prepared to do and thus furnish bail. This, my lord.
Because we'll have to dispose of that IA also. Wait for the time being, let it come. Okay, we'll dispose of both. This is item 14.
My next item is same accused person. Offense is also same.
Okay.
So both of them can be taken up
Okay.
together.
Here
Next
also
item.
you have filed.
Yes.
Here also the statutory period expired.
Yes.
Okay. Let it come, huh?
Okay.
Call for a code, huh? Okay.
Item number 17.
May I please, Lords?
Yes.
Lordship, this bail application has been filed by the accused persons, my lord, and the interim
AB.
my lord.
Okay.
An interim bail was granted by this honorable court on 21st, my lord, October directing my lord, the accused persons to appear before the IO of the case for registration of his statement, my lord, recording of his statement. Accordingly, I went to the my lord, the IO of the case, my lord, on 24, my lord, on 25, on 26, my lord, again when the matter was listed again before this honorable court, again directed me to appear before the IO of the case on 31st, my lord. My lord, I keep on visiting the officer before the officer in charge and the IO of the case, my lord. On my lord, 31st also, my lord. And
Do you have the record of you having visited the IO of the case?
Yes,
or appeared before the IO?
yes, my lord. Yes, my lord. My lord, I'm sorry, it is in low seat. And the my lord, mobiles they have sought for has also been deposited with the IO of the case, my lord. Now, my statements are not being recorded, only saying that no, we are not in a position to record your statement. So therefore, they again come on the other date, my lord. It is keep on going. My lord,
On his appearance, he was not arrested.
not my lord, formally arrested, and later
Not arrested and released also.
yes, my lord.
Okay.
And bail
statement
bond
not
has also,
recorded.
yes, my lord. Only a statement is not yet recorded, my lord. Everything has been complied with, my lord.
Why?
They are saying that they are busy in other work, so therefore they are not getting time to record my statement, my lord. But altogether, I spend in the police station for altogether.
Mr. Loy, is it possible that the person has been arrested and not yet not recorded his statement?
Yes, Lordship, what happened in this case, Lordship? The device involved in this offenses, Lordship. The IO says they found two devices which was involved in the offenses, but the petitioner says he lost his iPhone 15 and he denied another phone number, Lordship.
So that whatever his statement, even if he give a false statement also, that has to be recorded. After all, his statement, whether he gives, because it is, it is apparent that the accused will never tell the truth before the IO.
Yes.
Whatever may be, but then it's your duty to record it.
Yes.
Whatever statement he gives, but it's your duty to record a statement.
Lordship,
and then your duty to investigate on it whether he gives a correct statement or not.
Yes. Lordship, even his reply to the notice, Lordship, both the reply also contradictory, Lordship. May I read the,
what is this? This is your appearance before the IO of the case.
Yes,
on,
my lord.
On where, when?
On 24, my lord, on 25, 26, 31st, my lord, and 2nd November, 1st November, 2nd November, my lord. I keep on appearing before the my lord, IO of the case for giving my.
Now, what is your submission? Now, since he is appearing, he is cooperating.
Yes, ma'am.
Now, he is entitled for.
Yes, Lordship, he just appeared before us, but he did not disclose. There are 47.
You cannot compel. You cannot. Can you?
Lordship, there is 47% involved in this sitting, Lordship.
What is this case? What is the allegation?
Lordship, the fact of case is that in the competitive examination, Lordship, this applicant provide the student with Bluetooth device, Lordship.
Okay. What is this?
And as per the CDR record, Lordship, there are 42 subscribers within the periphery of the compound, Lordship.
42 subscribers.
There are so many to unattend, Lordship. So the custodial inquiry of this accused is necessary.
Custodial interrogation.
Custodial interrogation, Lordship, is both.
Then he need to be taken into custody. You make a prayer. You investigate.
Yes, in the city, Lordship, pray for the election of the
file objection. You are not filing objection also. How it can be?
Since
unless you file objection.
Yes.
He is already under protection, isn't it, by interim order?
Yes.
Interim interlocutory, anticipatory bail.
Yes.
You file objection if that be so. If that is correct statement.
Yes.
If he is trying to,
though it is in the CD, Lordship, it is in the CD, Lordship.
Hide something.
Yes.
Or
instead of filing, Lordship, may kindly peruse the CD, Lordship. What the
where is the CD?
We have two CD, Lordship. One is original and other is the scan copy, Lordship.
See, because there is subsequent development, he has appeared before you for four occasions.
6 times, my lord.
Six times. You have not recorded any statement. Some statement you
No,
could have
yes,
recorded
yes.
and could have asked him to appear again, come again,
No,
but then not recorded any.
not 6 times, Lordship. On the
My lord, as per my record,
after granting interim, he was appeared before both the police station. Since there is two cases, Lordship, two FIR. One is at Simpu and other is at Niti Bihar, Lordship.
on 24, my lord, I appeared. Again on 24, I am asked to come again on 25. I accordingly came. My lord, again on 26 and 31st, 1st November, 2nd November, my lord. It is on record, my lord.
And Lordship, there is a possibilities of involvement of officials also, Lordship. That's why custodial inquiry is necessary, Lordship.
In what examination?
The KP, Lordship, can be the one assistant, Lordship.
My lord, no, but there, my lord, for recruitment to the post of my lord, the lay assistant, my lord, recruitment process was initiated and the center was given in the state of Arunachal Pradesh also, my lord, for lay assistant, my lord, basically. And if Lordship perused the, my lord, the FIR, there is no name, my lord, even my name is not, also not reflected, my lord. It is in case of, my lord, other accused persons, my lord. My lord, basing on the statements of the other accused persons, my lord, I am implicated, my lord. Therefore, my lord, there is a, my lord, the clear, my lord, the settled position of the law that basing on the statements of the other accused persons, my lord, I cannot be implicated, my lord. And the documents which they have sought for, that has already been furnished to the, my lord, the IO of the case. Even they are asking for the production of the, my lord, the 2 mobile handset, my lord. That has lost of that, my lord, the mobile 2 handset has been also given, my lord. My lord, everything is before the IO of the case. Only thing is that they are not recording, saying that no, you are not the producing that some my lord, the mobile phone, which is not at all with me. I'm my lord, fully cooperating with the IO of the case, and I'm ready to cooperate with the IO of the case, my lord. My lord, in such case, my lord, this bail, my lord, may be made absolute, my lord.
Lordship,
At least, my lord,
the student, picture of student.
I am not the accused person, my lord. To make fair submission, my lord, I am not the accused person. My lord, there are so many other accused persons, my lord. They might have involved.
So far, 10 student candidate was apprehended, Lordship, arrested. They disclose his name, Lordship.
And my lord, before this case, I never been to this state, my lord, Arunachal Pradesh, my lord. I'm permanent resident of Haryana, my lord. I have not.
So Haryana think that the Arunachal is a very small state, would not know about the Bluetooth.
My lord. No, my lord. My lord, that I am ready to cooperate with. So therefore, my lord, keeping, my lord, calling the accused person time and again for in the just my lord, the name of the, my lord, investigation, my lord. That is also not correct, my lord. Statement can be recorded straight away.
Regarding the integrity of the. When you were directed to appear before the IO again?
My lord, they are, my lord, keeping me even suspense, my lord. They are not giving notice, my lord. On 2nd, I appear, my lord, Sunday, my lord. On Sunday itself, my lord, I left back to my home state.
Lordship, from the record, Lordship, he says he didn't receive the notice, Lordship, but he submitted the reply of notice, Lordship.
That is earlier notice, my lord. Earlier notice, my lord, replied. It is in reply to the, my lord, the earlier someone.
There is 2 reply, Lordship. The 2 reply also contradictory, Lordship.
But my lord, I am ready to cooperate.
So many things.
Yes.
Just a minute. Strong. These statements are to.
Well, I'm ready to
so what
cooperate.
we'll do?
Yes, madam.
Need to peruse this. Need to see this.
Yes, Lord.
It's a bulky one, and then you have a next. We'll take up this matter again day after tomorrow.
Yes.
Well, day after tomorrow. May I pray, my lord? In that case, my lord, I am keep on coming, my lord. I will be having personal day after tomorrow, my lord.
Then when?
My lord, may I find it on 11, my lord.
11. So because this record need to be perused.
Yes, Lordship.
So
I flag the green flag is Lordship. I highlight some statement of Lordship.
the statement of
IO Lordship, and the last two green phase Lordship is his statement. He replied notice Lordship under section 35 Lordship.
Okay.
In the meantime, my lord, I'll file my additional affidavit also, my lord, bringing all records, my lord.
I think because you say that you have appeared.
Yes, my lord.
And then
Receipt is also there,
two
madam.
police stations, huh?
Yes,
One
ma'am.
at Chimpu and one at Niti Bihar. So you have to clarify.
Yes, ma'am.
So 6 times,
I
not
appeared.
in both, probably, not in both. Probably you have appeared before Chimpu 3 times.
In both the police station, my lord, I appeared
6 times.
6 times, man.
Okay, you bring those also, those things also on record. Okay. Mr. M. Kato, and counsel for the petitioner submits that after obtaining the interim anticipatory bail, the accused applicant has appeared before the eye of the case for over 6 times
Madam.
and praised for allowing him to bring on record those documents showing his appearance before the eye of the case by filing additional affidavit. Mr. Lloyd also submits that he has
My lord, I was
received
arrested and released on bail, man.
arrested and released on bail.
Yes, man.
Then in that case, it's very difficult then.
Yes,
Then arrested and released,
In-
then it will have to be
in my
a
additional affidavit,
cancellation.
madam.
yes, Lordship.
Then it have to be a cancellation then,
Yes.
unless it is cancelled.
In that
If he is cooperating, then cancellation will be difficult.
Yes,
in fact, his statement that he's cooperating, but no, in fact, he is not cooperating.
What do you mean the cooperating? Is he not appearing before the police?
Yes,
My lord,
You
things
cannot
which is-
compel him to disclose.
Exactly, my lord. Things which is beyond my control, my lord. Keep on asking me to, my lord, produce the, my lord.
You want that he should admit what he has not done. That cannot be.
no, for the investigation purpose, Lordship, there are 47 accused, Lordship. So there is chances of Lordship alerting.
You bring out that record also. Bring out a record that the arrest and release also.
Yes, my lord. In my additional affidavit, my lord. Additional affidavit, I have stated, my lord. First additional affidavit, it is on record.
Additional affidavit you have
Yes, ma'am.
already filed.
Yes, my lord. On my lord, my lord may kindly peruse my additional affidavit, which has already been filed before, my lord, after 24th, my lord. My additional affidavit. Page number 36, 38, my lord, and excerpt 1 series, my lord. On 24, my lord, I appear before the, my lord, the officer concerned, along with my bail application. Accordingly, my lord, page number 39 is the, my lord, my arrest memo.
39.
Yes, ma'am. Additional affidavit one.
Do we have the 39 page here?
My lord, it might be in the additional
37
affidavit.
up to 37. Not beyond that.
No, my lord, additional affidavit.
No, additional affidavit.
Page, in bail application number, my lord, 155 of 2025, my lord. I'm sorry, my
There
lord,
is
it is in
affidavit.
page number 36, my lord. And except 1 series. My lord, we are on bail application number 155, my lord.
Appearance.
Appearance. And my lord, the arrest memo,
Where is the arrest memo?
37, page number 37, my lord.
Okay.
And later on, I was released, man.
Where is the release?
On same day, man.
Do you have the release order?
And basically, they are not giving the release order, man.
What is the maximum punishment? What is the offense?
Offense is, my lord,
Section 61.
61, my lord, 1 of criminal conspiracy. My lord, 1121 or petty organized crime. 1318 subsection 4 cheating, and my lord,
Read with 66D.
yes, my lord, 666D of the
Unfair.
unfair means in prevention of unfair means. And-
Mr. Okay, Katulani counsel for the petitioner. So, also had Mr. D. Loy, learned public prosecutor for the state. Stop, Ankara. By an order dated 28/10/2025. No, by which order? You were granted?
21st, my lord. 21st
Not
October
21st,
2025.
21,
21, my lord.
2025.
Again extended on 28
The
October.
accused applicant was granted interim anticipatory bail with the direction to release him on execution of a bail bond of rupees 25,000 with two sureties of like amount to the satisfaction of the arresting authority with certain conditions. With the following conditions, condition number 1, 2, and 3. Okay, at page of that order, 1, 2, and 3. Stop. In compliance of the condition number 1, the accused applicant appeared before the eye of the case on 24/10/2025. Before the eye of the case. It's an ET Bihar case, okay? On 24/10/2025. Stop. On such appearance, the accused was arrested in connection with the above Niti Bihar Police Station PS case number 18/2025 under section, all those section, 61(1)/112(1)318 within bracket 4 BNS read with section 66D IT Act 2000 and section 10/11 of the public examination within bracket prevention of unfair means bracket close Act 2000. What is this Act 2000?
4.
And after completion of the necessary formalities, he was released on bail on the strength of the interim anticipatory bail dated 21/10/2025. And after execution of the bail bond and furnishing execution of the bail bond and on completion of the necessary. The counsel for the petitioner further submitted thereafter also the accused applicant had appeared before the eye of the case on next date
on 25 26
no 25/10
25/10/2005 madam 25/26 madam on both day. but there is no record, madam. And on
25, wait, no record?
no record, madam. Just I appeared before the eye of the case.
25?
25 and 26, madam.
25
24,
and
25, 26, madam.
25, 10,
Yes, madam.
25, 10, 20,
And 26.
24,
also.
and 20, comma, 26, 10, 20, 24, and on 31,
31, madam.
31, 10, 20, 24.
Mm, 1st November, 2nd November, madam.
Okay, not n, comma, and 1, 11, 20, 24. That much?
Yes, madam.
Okay.
And handed over the, madam, the mobile phone also, madam.
Stop. He has all, the accused applicant has also
Handed over one mobile phone, madam. Seizure memo is
Okay,
also given,
okay.
madam.
His mobile was also seized by the eye of the case on
31st, madam.
Hmm?
On 31st, madam.
on 31st.
Yes, madam. Seizure memo as per madam. Seizure memo.
On 31st, 10, 2025. It is submitted that the accused applicant has duly complied with the conditions, direction and the condition imposed upon him in the while granting the interim anticipatory bail and cooperating with the eye of the case as and when called for. Stop. He is all. He further submits that the accused is, or accused, although is from Punjab, but as and
Haryana,
when,
Haryana, madam.
Haryana. However, as and when he has been called by the IO, he used to appear and he is ready to appear in future also. Stop. Future also, and submits that since the accused applicant is cooperating with the IO of the case, his interim anticipatory bail may be made absolute, regularized and made absolute. Stop. Para. Mr. Loy Lana PP, however, submits that although the accused applicant is cooperating and appearing before the eye of the case, however, he is not.
There is a 47 accused lordship involved in the lordship in this, all this offense. lordship.
Okay. So how many of them have been arrested?
10.
10. Out of
10
47 accused, out of 47 accused involved in the instant case, only 10 accused persons have been arrested.
Yes, lordship. And mention the petitioner's name
including
as
the
Kingpin lordship.
Huh?
As a Kingpin lordship of this record lordship.
Okay. Only being mentioned, he was arrested.
Yes.
Okay. And then arrested, and the accused in the case revealed the name of the present accused applicant, based on which he was summoned, I think.
Yes.
Okay, based on which he was summoned. Stop.
Summoned but not appeared, lordship.
Okay, but then after that, after this
after-
obtaining, he appeared.
Yes.
Stop. Para.
When I received, madam, I apprehended from this.
Upon hearing the parties and on perusal of the records, it appears that the accused applicant is cooperating with within the eye of the with the eye of the case for investigation of the instant case, and he is appearing before him as and when called for. In view of the above, and as the accused has already been arrested and released on bail, now this court, the interim bail granted to the accused on 21/10/2025. He is hereby regularized and made absolute with the same terms and condition. With the further condition that same terms and condition. Okay, with the further condition that the accused applicant shall appear, cooperate and appear before, continue cooperate and appearing before the IO of the case agent when called for. Okay. This bail order shall be read along with the order dated 21/10/2025. Start with the above this bail application stands disposed of. Okay.
The original, there is one.
The return the case diary. Similar order?
Yes.
Okay.
Yes.
In Malad.
No point. Already arrested and released. No point. And if he failed to cooperate, then you see
Yes.
Yes.
your role comes. File an application for cancellation.
Yes.
Okay.
Malad, another is also same. Malad.
Same order, similar order.
Similar. Much of
Item number.
Same number, only number will change.
the number will. That is, this one is 18, that one is 34. Malad.
Okay.
Simple PS case number.
Yes. Only number will change. Huh? Yes. This was
Section will also be little change.
16, 17. Section also same.
Almost same, Malad, but Malad, IT Act has been invoked past and unpaid means is also later, Malad.
But
almost same, Malad.
okay, see the order. See the okay. Okay.
Much of.
Pass over matter item number 13 and 14.
Or 14 and 15. But item 14 is Itanagar PS.
Same person. Item 15.
15 same person, but the difference is there was accident between Fortuner, collision between Fortuner and Tata Sumo. During investigation, it was found that the Fortuner was purchased illegally on a stolen vehicle. So my name was taken and I was shown to be arrested on 24th August. And in that case also, mandatory period is over for filing charge sheet.
I've submitted the charge sheet. It is already charge sheeted. 14, item 14.
15.
Oh, you submitted the no charge sheet?
No.
That is why we have been.
Item 14, no charge sheet. Item 15, charge sheet has been filed, but after the lapse of the mandatory period. So in that case also, it's covered.
Indivisible right, when it expires, then he has indivisible right to be allowed on bail. But after expiry, even charge sheet was filed. After expiry, charge sheet was filed. He has not availed any legal rights. So that will not be a case for the bail.
My lord, before filing of the charge sheet, I have filed my regular bail application.
Regular bail application, no application for any.
Default, I have not.
Earlier,
at the time,
it is 167 plus 3. No, it is 187 plus 3. BNSS.
my lord, with this regard, may I place the same judgment, paragraph 46, at phase number 24.
Now, item 14 is,
Item 40, there is no dispute with regard to the filing of charge sheet because learned fifth is also conceded that no charge sheet has been filed. But in item 15, charge sheet is filed, but after the expiry of 60 days. Because in Doimuk PS case number, the offense are less than 7 years, so the mandatory period is 60 years. But in item 14, it's 90. Mandatory period of filing.
In 14, I have filed the charge sheet. That is,
oh,
in 14, I have filed the charge sheet.
he said that 14 not
14.
filed.
No, yes.
Itanagar PS
Oh, you have to clear.
or Doimuk PS.
First of all, you have to be clear about your case. Don't confuse.
14
And
I
now
have
we'll not talk about the 15.
Yes.
Okay, keep the 15 away. Okay, don't mix it up.
Okay.
Where is 15?
14 is Itanagar PS case number 102.
This is IA is in 15.
Yes.
Okay, keep it away. Now only 14. Whether in 14 charge is filed?
Yes, I've submitted before yourself.
Charge sheet?
Till yesterday, the update was no charge sheet.
Sorry, Your Honor, CD, sorry, Your Honor. Sorry, I apologize. CD, I have submitted.
No way. CD where? Okay, this is case study.
CD, I have submitted.
In item 14?
Yes, yes. Otherwise,
so no charge sheet filed?
No charge sheet. CD.
Hard, Mr. Amete, learned counsel for the petitioner.
Yes, indivisible right.
This is an application filed under section 483 of BNS. Now, Bharatiya Nagrik Suraksha Sanhita 2023, praying for release of the accused, namely Sri Sagar Burman, in connection with Itanagar. This was filed when? 28?
Church, yes, Lord.
Okay, just a minute. Not this is on 28/10/2025. The petitioner moved this bail application under section 483 of Bharatiya Suraksha Nagrik and Bharatiya Nagrik Suraksha Sanhita 2023, praying for release of the accused, namely Sri Sagar Burman, in connection with Itanagar PS case number 102/2025 under section 111 within bracket 2 B within bracket 3 within bracket 4 within bracket 5 stroke 317 within bracket 4 stroke 336 within bracket 2 stroke 340 stroke 61 within bracket 2 of BNS 2023. The accused was the accused is stated to have been arrested on when he was 37/2025 in connection with the above PS case. However, during the pendency of this bail application, the statutory period of 90 days in the instant case has expired. On when it expired?
By 29.
29/9.
10.
29/10/2025.
Expired any 90 days.
However, the IO of the case failed to file charge sheet against her, charge sheet into the case till date. Stop. Huh? Therefore, the applicant, by filing this IA criminal 103 AP 2025, by filing this, the applicant filed this interlocutory application under section 187, 187 within bracket 3 of Bharatiya Nagrik Suraksha Sanhita 2023 for grant of default bail stop. Para. It is submitted that the accused was arrested on 27/10/2025. However, despite of despite of expiry of the statutory period of 90 days, the police failed to file charge sheet into the case, and therefore the accused is entitled to a default bail under section 187 within bracket 3 of BNSS 2023. Stop. Huh? Mr. Peraha, Mr. Jitado, landed additional PP for the state. State produced the case diary. However, he fairly submits that although the accused was arrested on 27/10/2025, and despite of expiry of the statutory period, the police failed to file charge sheet against the accused till date, and therefore he has considered the submission of the Land Council for the petitioner that the accused would be entitled to default bail for his default bail under section 187(3) of the BNSS. Stop. Para. it appears that the record appears that the accused was arrested on 27/10/2025, and despite of expiry of 90 days, statutory period of 90 days, the police has failed to file charge sheet into the case till date. Under the circumstances, the accused has acquired an indefeasible right to consider for his release on bail. So in the instant case, the accused is ready to furnish bail. Stop in view of the above, and then accused has accrued an indefeasible right to the accused for to consider for his release on bail, and the court has no discretion. Court cannot exercise its discretion in this regard. Stop. Under the circumstances, yeah, and in view under the circumstances and in view of the above, this bail application is allowed. The accused is directed to be released on default bail under section 187(3) of the BNSS on execution of a bail bond of rupees.
Well, let me kindly 5,000. I'm a private driver. I'm a private driver. May kindly.
What was the allegation otherwise?
Dealing of stolen property vehicles.
Oh, he is
from interstate. They have a crime, organized crime.
You are big sword.
Syndicate.
No, my lord, I was private driver. The prime accused person engaged me as a driver. I didn't have the knowledge. I just drove the car.
Transport the vehicle from here to there.
That was the allegation. But
Okay.
I was not the main dealing person.
You get
all of them have been released.
You get big chunk of share then.
Yes, member is also punishable equally as the prime accused member of the organization.
It will be a small 25,000. Yeah. 25,000 on execution of a bail bond of rupees 25,000 with who he is from outside state.
Yes.
With two surety of like amount to the two surety of like amount, one of which shall be the resident of Arunachal Pradesh, to the satisfaction of the which court will release
CJM.
Okay.
Yeah.
Of the Chief Judicial Magistrate.
Sessions.
Sessions.
My lord, it's a sessions court.
Session court.
Yes.
Tribal by session.
Yes.
Okay, session court. Stop. With the further condition that he will, the accused shall appear before the eye of the cooperate and appear before the eye of the case agent when called for. That the accused and that he shall where is CRPC? CRPC?
CRPC. BNSS.
CRPC permanent. That he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officers. Next. He is from outside the state.
Presently here, my parents, everyone is settled here.
Okay. Then okay, that he shall not leave
It's
jurisdiction court without
Permanent resident is given in the
Yeah,
cost
outside,
title.
but now presently my parents, everyone is settled here.
Permanent is,
Okay,
address is
without
Kuch Bihar, West Bengal.
prior information to the concerned court. Okay, with the above this this bail application as well as I stands disposed of. Okay. And in 15.
15, my lord.
15 here. 15 is staff. Same accused in 14 and 15.
15, my lord, what happened? In Chiputa, there was a collision between Fortuner and Tata Sumo. So during investigation, Fortuner was found to be the stolen vehicle. So in course of investigation, my name came up. So I was arrested, shown to be arrested on 24/8 and sent to the judicial remand. So in that
He
case,
was already inside.
yes, I'm
in
already
connection with
inside.
some other case.
Yes.
Yes.
Okay.
Actually, in connected because those vehicle which was involved in collision was purchased.
Accused was found to be a purchaser of the Fortuner vehicle.
Mhm.
Was found to be purchaser.
Yes.
Same accused person.
Yes.
Yes.
There he was a member of the
Okay.
organized crime syndicate.
So charge sheet filed after.
After expiry of
Expiry.
60 days.
It is on.
But when charge sheet was filed.
Charge sheet.
When he filed this bail application. Charge sheet was filed after the bail application was filed before this court.
Before the court.
Before trial court.
Yes.
No, after filing of the bail application. During the pendency of the bail application.
A bail application was filed on 27 before.
27/10.
Yes, 27/10. Bail
Okay, charge
application.
sheet, when the charge sheet was filed.
That is not written here. This is a double T message.
You confirm it?
Actually, my lord, yesterday the information received was not
Okay,
filed.
you
I think-
confirm it? We'll take this matter day after
Yes.
tomorrow. Okay.
That is not written here.
Okay, then 15
My lord,
is praised for by.
after break, my lord.
Learned counsel for the, learned additional PP. Let this matter be listed on next day. Day after tomorrow would be?
Tomorrow is a holiday.
Day after tomorrow, I'm saying.
Yes, they.
My lord,
On 6th.
my lord, can it be taken after 2 or last part?
No, no.
Necessary.
I have to collect phone number also.
Let him collect the entire,
Yes.
not the half information, okay?
Okay. Oblige, Your Honor.
My lord, in the morning, one CRP was mentioned and permitted for tomorrow, but tomorrow is holiday, so maybe taken up day after tomorrow.
So we'll take up tomorrow?
No, tomorrow is holiday, my lord. For
Maybe,
CRP.
because you knew it and you mentioned it.
No, mention was made by another. He left. He requested.
He left. Let him take up the tomorrow.
Tomorrow is holiday. Of course.
He knew it. Holiday, that's why he mentioned. Okay. Day after tomorrow. Yes.
Item number 19.
Yes. Is it?
I'll file the rejoinder in respect of respondent number 5, Lordship.
What about the other respondents,
Respondent number 2 is, Lordship, yet to,
other than respondent number 3 and 5?
yes, Lordship.
Respondent number 3 and 5 has filed their affidavit,
Yes, Lordship.
and rest of the respondent not yet filed.
Yes, Lordship.
So who represent them? 1, 2, state. State has already filed or what?
Respondent number 3, we have filed, Your Lordship.
3 is Deputy Commissioner. What about 1 and 2?
We have filed.
Not yet filed. And what about respondent number 4? Not yet filed. You're seeking time.
Yes.
You are for?
Lordship, I'm for respondent number 5, appearing on behalf of M. Kato.
Okay, very good, Geology. Okay.
Your Lordship, for respondent number 4, we are not going to file, Your Lordship.
4, you are not going to file.
It will cover, Your Lordship, respondent number 3 affidavit, Your Lordship.
Okay. You have filed reply to the affidavit filed by the respondent number 3. When? It is not seen here. When did you file? Okay, affidavit. Okay. Mr.
Titato.
Learned counsel for the petitioner submits that although he has filed affidavit in reply to the affidavit in opposition filed by the respondent number 5, however, seek some more time to file affidavit in reply to the affidavit so filed by the respondent number 5. Stop. Ms. Pango, learned counsel, appearing on behalf of the respondent, state respondent number 1, 2, and 4 submits that and prays for some more time to file affidavit in opposition in respect of respondent number
1 and 2.
1 and 2. However, she submits that the state is not going, the respondent number 4 is not filing its affidavit as it will cover the affidavit in opposition filed by the respondent number
3, Your Lordship.
it would cover, huh? Okay, it will cover the affidavit in opposition filed by the respondent number 3. Stop, huh? Okay. Miss
Why Gao?
Gao, learned counsel appearing on behalf of Mr. Kato. Learned counsel for the learned Kato is for respondent number
5, Lordship.
okay, the learned DSGI for the respondent number 5. You are also going to file.
Lordship, we have already filed our affidavit.
Oh, sorry, 5 for okay is also present. Stop, huh? In view of the above and as prayed for, let us the respondents are granted, whether the respondents are granted and the petitioners are granted. How much time?
3 weeks, Lordship.
3 weeks time to exchange their affidavit.
Lordship,
At least this matter after.
there is an interim, Lordship.
What interim was there? Hmm? By which order? Status quo. Okay. The interim order to maintain the status quo. Sorry, the interim status quo order passed earlier shall continue till the next date of listing. Okay.
Obliged, Lordship.
Item number 2222. Your Lordship, as per the record, Lordship, respondent has filed their affidavit in objection that I have yet to receive, Lordship.
Okay, respondent.
Yes, Lordship. So, Lordship.
So they are private respondent.
Yes, Lordship.
They have filed.
Yes, Lordship. But I have not received yet, Lordship.
I can 22 and okay.
2021, 22. Okay. Lordship, this is 2021, 22, Lordship. The three matters they have arising out of same affair. 2021, 22.
Okay, 2021, 22.
Yes, this arising out of same affair, Lordship.
Okay.
So, Lordship, we have to produce our updated case study also.
Case study was called for.
Lordship, yes, Lordship. So, Lordship, it may be listed again for admission hearing, Lordship.
Mr. Tapak, planning counsel for the petitioner is present. Stop. Ms. Lhage, planet additional people. Press for some time to produce the updated case study.
Yes.
Stop. The respondent number 2 is, the record reveals that the respondent number 2 has filed. Who is respondent number 2? Complainant has filed affidavit in opposition. Neglect. In a file objection, file objection. Who represent respondent number 2?
Lordship, in the court case, Lordship, this Tacha Roma, Lordship.
Okay, stop, huh? In view of the above, and as prayed for by the state respondent, let this matter be listed when?
Lordship, after 2 weeks, Lordship.
After 2 weeks.
Lordship.
On which date the additional PP shall produce the updated case diary?
Lordship.
Okay.
Much obliged, Lordship. Item number 23.
Please, your Lordship.
Yes.
It's a contempt petition. As per earlier order, notice the step was taken upon the contempt note,
Okay.
but the report was awaited.
Still awaited. Okay.
I may be allowed to take rest to my.
Okay. In view of the office note dated 3/11/2025, Mr. Udeka, Lana counsel for the petitioner, prays for allowing him to take fresh steps upon how many respondents?
Only so.
Okay, upon the respondent. Stop. The prayer is allowed. Stop. Steps for notice upon the respondent number. The sole respondent be the by register post
Yeah, by register post.
with 80
Yes.
as well as by usual process
Yes, by the.
within a week from today.
Yes.
So list this matter after 4 weeks.
Okay.
Okay.
All place.
Item number 24.
Ma'am, I'm not afraid that this contempt proceeding may be closed
Okay.
because during the pendency of the contempt proceeding, the respondent authorities have complied with order dated 4/4/2025.
Okay, Mr. Adil RL Thungon, Land Council for the petitioner, submits that the respondent alleged contemptor has complied with the order dated.
So
Which
4/4/2025
4/4/2025
passed in WPC 600 of 2020.
passed in WPC
600 of 20.
600/2024. And in view of the above, in view of the above, and as prayed for, this contempt petition stands closed. Okay.
Item number 25.
Close and dispose. Okay.
May I please, Your Honor?
Yeah.
Lordship, in this this is the matter, make appeal. It is transferred recently from Guwahati High Court Principal Bench to this
on good ways. But today in the morning, I have been instructed by the company to beg some time from this on-call court because the file is not hand over yet to me. Earlier, the conducting councillors, Mr. R.D. Mozumdar from Guwahati High Court Principal Bench, now he is reluctant to come here. That's why company endorsed me. So I am filing Okalat now.
Okay.
So I may be given at least 1 week time, my lord.
Mm. When this was transferred?
This was transferred recently.
Okay.
Only in this morning, I was informed that this was transferred.
Okay. Mr. Udeka, Land Council for the appellant submits that this MAC appeal has recently been transferred from Guwahati to Itanagar. And he has been engaged by the insurance appellant insurance company to appear in the matter. Therefore, pray for some time. How much time you said?
2 weeks, my lord.
Pray for granting 2 weeks time.
Yeah.
So you have to file then in that case wakalatnama?
Yes, my lord.
Okay. To file wakalatnama. Prayer allowed. List this matter after 2 weeks.
2 weeks, yes.
Okay.
I will not.
Item number 26.
Not yet filed.
We have
Affidavit.
filed. We have filed
You have filed?
on behalf of 6, 7, and 8.
Okay. Who has not yet filed?
Lordship.
The Union of India.
Yes, Lordship.
Yes, you.
We will take instruction, Lordship. Therefore, we may be granted some more time.
You were smiling. I thought you were. You have already filed.
No, Lordship.
It's otherwise. Okay. Miss Gao, Land Council appearing on behalf of the respondent. You are respondent
1 to 5, Lordship.
number 1 to 5. How much time?
Lordship, 3 weeks.
Further 3 weeks time to file affidavit in opposition. The prayer having not been objected is allowed. List this matter after 3 weeks. Okay.
Obliged, Lordship.
Item number 27 and 28.
Yes.
Lordship, this matter is with regard to this ref by post permutation marriage. In this case, Lordship, I have filed this application because the co-accused has been already lectured by the learned court below, saying that she is not involved in the case. Right. Yes, Lordship, there is a serious procedural defect in the case because as per the police report, charge sheet report, even the co-accused was not even charge sheeted.
We are in 27, item 27.
Yes, item 27. Kindly see the page number 43.
Page?
Page 43. 43.
Just a minute. Just a minute.
This is the charge sheet copy.
Just a minute.
This is the charge sheet report. In the last concluding paragraph.
What did you submit? What is the offense involved here? Just a minute.
Offense is,
Where is the allegation we do? Where do we find the allegation? FIR?
go by this FIR. As per the FIR, there is an allegation of ref.
Okay, page.
I'll see.
FIR is at page.
Item number 31.
Yes.
My lord, by this IA,
What is this IA
I
for?
am seeking permission to adduce additional documents which was obtained through RTI during the pendency of this matter.
In writ petition.
Yes, my lord.
So that can be allowed? Yes. Okay. Heard Mr. S. Koyang, Land Counsel for the petitioner. Oh, this is only seeking permission?
Yes. Permission to adduce additional documents, my lord.
Adduce additional, okay. By filing this application, the applicant seek permission it will be produced, production of the additional document.
Yes, my lord.
Okay. This court to produce additional document in writ petition number 314 by filing
14.
It will be additional affidavit?
Yes.
By way of filing additional affidavit, isn't it? By way of additional document?
Additional affidavit.
Okay, by way of filing additional affidavit. The prayer, Mr. Getso, Land Counsel has no objection. Land Counsel for the respondent has, this one, Miss Sangita, Land Counsel for the land is government
for
advocate for the
respondent.
state respondent and Gatso for the private respondent has no objection.
No private department.
Oh, you are for department?
Horticulture department.
Horticulture department.
Respondent number 5.
Okay.
Your Worship,
Oh.
I'm appearing for 1 to 4.
Okay, 1 to 4. Oh. Sangita for 1 to 4 and Mr. Gatso for respondent number 5. There is no objection. Okay, in view of the above, this IA is allowed. The applicant writ petitioner is allowed to file additional document by way of filing additional affidavit stuff with the above this IA stands disposed of. Okay.
Yes, ma'am.
Okay. And then this, what about this?
In
that case, you file additional thereafter, only it will be listed for admission.
We have to file a affidavit as well. After he filed his additional affidavit.
Then you have not yet filed any affidavit. IA dispose your prayer allowed?
Yes.
IA dispose, now you can file additional affidavit by enclosing the documents which you wanted to file.
All
Okay.
right, madam.
And then after filing only, they will be able to file affidavit.
All right, madam.
Okay. So
My lord,
this matter after 3 weeks?
Yes, sir.
After no, my lord. I will be filing very shortly.
Okay.
Okay, after 3 weeks, no problem.
After 3 weeks. Okay.
My lord, in the main case,
In
I have prayed for interim relief, my lord.
the main case, you filed the additional affidavit document first.
No, my lord, whatever document is available, on the basis of that, I am praying.
What is this? Just a minute.
Your lordship has passed an order on 27 July 2025 to consider the interim relief in the next date of hearing. And short date was given. But on the next date, that could not be considered. Only another date was given for filing affidavit. So this way, this court is not able to consider the matter for interim.
What is this matter about? Otherwise?
This is a land allotment matter, madam.
Eviction, lordship. Lordship.
Yes.
Earlier, this court has was opinion that they will court will consider the interim on next date. However, on the next date, the court.
No, see, Land Counsel, Mr. Koya.
Yes, madam.
I think it will be your advantage if we see, because what the court did not pass any interim order on that day, considering the documents produced by you.
My lord,
And that
actually,
is why normally prima facie, if the court satisfied, normally court used
my
to
lord,
pass.
actually what
interim order.
happened,
Now, your
the-
additional document will help you probably.
my lord, the additional document, it is already there in a writ petition. But the
Then-
difference is that one was in my possession, and now that I have adduced before this court is through RTI. There are some documents which is already there, but the authority has said that is not there. Only for that purpose, I have adduced the documents obtained in the under RTI, my lord. Already it is there in the writ petition.
On the earlier hearing, Lordship, learned counsel for the petitioner has prayed for the interim. However, the court was not inclined to grant so.
So on the next date also, it was not granted.
Yes.
My lord, in the next date, order was passed for filing affidavit.
Because interim was not granted. The council has
So on
prayed for
the
the
next date, in the first order says that the prayer for interim relief shall be considered on the next date. On the next date, it was not considered.
Not,
And
not
probably the court was not inclined.
Yes, Lord.
My lord,
Because on the document which you have relied upon was not sufficient to convince, enough to convince the court.
my lord, for filing affidavit was insisted.
Lordship, the petitioner has already prayed for the interim on the last occasion. However, this court was not inclined to grant so.
That is why I'm saying. So if your additional document, if that is authentic and if you can satisfy the court, probably on that day, the court may also relooked into and think about. Because the document is, which you have relied upon here in this writ petition was probably not
But the same document.
No, then in that case.
Same document.
May I, Your Lordship?
What is the
We have
difference?
received one instruction, so we'll be filing it. Till then, interim.
You'll be filing?
Yes, we'll be filing the instruction we have received from the DC.
You have already
Yes.
received instruction?
Yes, Your Lordship.
Okay.
My lord, in a motion stage also, similar prayer was there. Almost your lordship has passed an order for interim relief, but that has been
It was
deleted.
almost.
That has been my lord, that has been deleted only on the prayer that within short period of time they will be filing affidavit.
But if that was the same submission, then why you are
Lordship,
making the same submission?
On the first, Lordship, first hearing, it was considered, instruction was sought for. And accordingly, on the next date, I have provided the instruction before the Honorable Court. And considering that documents which I have provided before the court has denied interim.
No, then you see, then file by the next date, you have to file, otherwise the interim prayer will be considered. So you, by the next date, you have to file your affidavit.
Lordship, I have the documents which we have produced.
Document bring in into affidavit form.
In case affidavit is filed, it will be ready for final argument, my lord. So in between these days.
No, because here I still remember it was not enough or satisfy, could not satisfy the court, and probably the next bench also, it was not convinced to pass interim order. That is why the interim order was not granted.
My lord, kindly see only one photograph, my lord.
See,
from
this was way back in August. The respondent was granted to file affidavit. Now you see, within 3 weeks you have to file affidavit. Otherwise, what we'll do is in the admission stage itself, we'll try to dispose of.
Yes.
No need to go for hearing also. But let them file affidavit.
Yes.
They are delaying filing affidavit, my lord.
No, next day we'll make mention there here today then. Okay, Miss Hard Mr. is going on counsel for the petitioner. Staff, Miss Sangeeta, Planet Government Advocate for the respondent 1 to 4, and Mr. Gatso, Planet Standing Counsel for the Horticulture Department. Praise for Father 3 weeks time to file. Submits that they have obtained instruction and they have received instruction from their respective department, and is going to file an affidavit within 3 weeks and prays accordingly. Stop. The prayer is allowed. Stop. List this matter after 3 weeks. Stop.
Let
It is made clear.
Let it be 2 weeks then. If there is no interim order, let it be after 2 weeks.
That was two, that also,
They have to file the additional affidavit.
you
then
have to
only
file
we can
additional
file
affidavit.
ours.
In between these days, I will be fine.
Okay. That also 2 weeks, huh? Okay, it is made clear that, just a minute, then file within 2 weeks, failing which the matter shall be taken up based on the documents available on record. Okay.
Item number 34.
Your Lordship, I have filed this IA for implement of the applicant as a respondent number 6 in WPC number 287.
Implement of whom?
Implement of applicant.
Who is applicant?
Your Honor. Your Honor, applicant is a public spirited person, and he has been actively involved in the preservation of this forest reserve area. So, Your Honor, and because of him, this WPC has been initiated.
454. Because of him, WPC has been initiated.
Yes, Your Honor.
Then why he is not a party?
That's why, Your Lordship, I want to be part of this. I want to be as a respondent of this WPC.
You want to be,
Yes, Your Honor.
to be implemented in the writ petition?
Yes, sir. As a respondent number 3. 3 in WPC.
So you are a stranger?
Yes, Your Honor.
How it is?
Because, Your Honor.
Who is for the petitioner?
Sir, I'm petitioner.
You are for the petitioner?
Yes.
What is this petition for? What is this writ petition about?
Your Honor, this WPC 2666 is challenging the
266. Where do we find 266?
Sorry, 287. 287. It's challenging
Where do we
the
find 287. This is item 34.
Oh, sorry, 35.
34 is regarding the writ petition, WPC 454. 454 only. Are we in item?
454 only.
Sorry, Your Honor.
This is item 34.
Your Honor, 34 and 35 are same.
Oh, 34 and 35 same.
Yes, yes.
Now let us deal with one. 34.
Uh,
This is 34.
34, they are praying for direction upon the respondent authority, particularly the Department of Forest, Government of Arunachal Pradesh, to issue no objection certificate for creation of proposed Jipu Dodi as census village within the Deepa Reservation Forest in the district of Lower Siang, Arunachal Pradesh. Your Lordship.
Just a minute.
Okay.
What
545 WPC.
Yes, sir.
It's filed by you.
Filed by petitioner.
Okay. What is this for?
I have not.
Mm.
Nghe câu này nè. Này. Đây.
Yes. Have you filed additional affidavit, petitioner? Subsequent development, incorporating the subsequent development you are directed to file. Have you filed?
No, Your still not filed.
So, last order, have you seen? There is a direction while granting stay over there. You were asked to file additional affidavit.
Yes. We need more time to file additional affidavit.
Mr.
Endoji.
Learning counsel for the petitioner. Press for further 2 weeks time to file additional affidavit incorporating the subsequent development. Para. Miss Giete, Lana additional government advocate. For the respondent number 1,
Considering that time may be allowed because lots of
you are also filing affidavit. Are you?
lots of bullets. The task has been already granted.
Yes. Are you filing affidavit?
Not yet, lots of.
No, are you filing or?
Yes, we'll file.
Okay, Miss, also pray for some time to obtain instruction and to file affidavit in opposition. Prayer allowed. List this matter after 3 weeks. Okay?
Yes.
Lots of.
And then your IA, why? IA issue notice, you want to file?
Lots of last chance may be given after obtaining status code. They don't furnish us extra copies. Here,
Well,
better also.
why you did not furnish? You furnish copy? Mr. Land Council for the petitioner shall furnish requisite extra copy of the writ petition to the Lanet government, Lanet senior government advocate, the additional senior government advocate. You have a copy today?
No, no.
Within 3 working days from today, stop, huh?
Yes.
Okay.
Telling lots of status code will be.
Theoretically, unless.
My lord, regarding IA, we will file objection after taking instruction from my client.
Okay. Mr.
T. Tayum.
And counsel for the applicant. Stop. By filing this application, the applicant seek is implement in writ petition in WPC number 454 AP 2025. No. By filing this application under order 1 rule 10 within bracket 2 of the Code of Civil Procedure, the applicant seek his implement as respondent number 3 in the WPC number 454 AP 2025. Stop. Issue notice. Since Mr.
Endoji.
Land Council. For the respondent writ petition as accepted, accepted notice, no formal notice need be issued. Mr. Doji prays for some Mr. He wants to file objection after obtain proper instruction. If objection, proper instruction, staff, huh? And pray for some time. Prayer allowed. The prayer allowed, huh? Staff. List this matter after 2 weeks along with the WPC number 454/2025. Okay.
Lots of one more thing. In both the writ petition will have not been filed. So this status quo was first
In both, they are similar.
similar matters.
Okay, here also same, and in both same order. Here also they have obtained
Status quo. This one.
status quo. Order.
This one they have got the.
See, after obtaining status quo, if you fail to furnish copy, it will be difficult. Next, it will be vacated. Your status quo order will be vacated. You furnish within 3 days. Okay,
Okay,
same order, huh?
okay.
After 2 weeks?
After 3 weeks only,
3
we say 3 weeks.
Much obliged.
Item
If it is the same matter, in IA also same.
Yes.
IA also same, huh?
Yes, yes.
You have received a copy of the IA?
Yes, yes.
Okay. Same order.
Item number 36.
Your Lordship, in this matter, service report in respect of respondent number 2, 3, and 4 are still awaited.
You are for, Miss?
Lordship, I am for respondent 1 and 2.
One and two.
Yes, Lordship.
Okay. Part, Mr.
Sita, Your Lordship.
Lani counsel for the petitioner. Stop. Miss Gao appear.
Appearing on behalf of M. Kato,
Appearing,
DSGI.
okay. Appearing on behalf of Mr. M. Kato, DSGI, for the respondent number 1 and 2.
Yes, Lordship.
Stop. The service upon the respondent number 3 and 4 are still awaited. In view of the above, you want to file objection affidavit?
Yes, we will.
Okay. 1 and 2, and pray for some time to file affidavit in opposition. The service of notice upon, sorry, the service upon the respondent number 3 and 4 are still awaited. Stop. In view of the above, list this matter after 3 weeks. Okay.
Obliged.
Obliged, Lordship.
Item number 37.
May I please, Your Lordship?
Yes.
On behalf of the sole petitioner in this case, which represented the whole clan of Hemi clan, regarding this matter, this is the 4th time to list this matter for consideration of the stay or status quo matter order regarding this matter. So may I highlighting some brief of the case. First of all, my lord, may I see annexure 2, page number 18.
Just a minute. Huh?
This is
What is this matter? What is said?
for the compensation for stretching road of the Pumbung Yirlung to Takik Ling Tak, which is situated in Karle.
Okay, who are the respondent?
Respondent is a deputy commissioner as well as the DLRSO of the Siyomi district, Arunachal Pradesh.
You served copy to them?
Yes, already in the first day.
Who appears on behalf of the respondent number?
The government advocate, madam.
Okay, so are you filing affidavit?
We have received instruction, but then this is not complete instruction. So basically this between the private parties, but then here that other party has not been made a party. That
Okay.
respondent, Hedu clan.
The
It's Hemi clan, but then Hedu clan has not been made a party.
Oh, then Hedu clan, if you are claiming against the claim of the Hedu clan, then you may have to, I think, implement them as a respondent party.
I have pointed that earlier.
Then in their absence, the matter cannot be decided against them.
My lord, from the day one, I already told the honorable court that regarding this impugn order, it's clearly stated that some portion of the compensation have to be given in the some properties like trees, horticulture items, and the house.
Okay,
But
let them file affidavit then.
I have no issue regarding the day one date. They file whatever time, but at least give them some stay order regarding this matter, because the concerned authority, deputy commissioner LRS, though, give a full control over the land, compel the petitioner to leave vacate the said land, and they brought all the heavy machineries like pockline, JCB, dumper, and they start the cutting their own houses and their land, which see instead is stay in the said.
What is your instruction? You were asked to obtain instruction.
No, sir.
So I'm the agreed person who suffer the said land.
No, you were also permitted to array the representative of Hedu clan also from the very beginning.
Yes.
You have not yet implemented, it appears.
But this is the impugn order passed by the honorable.
No, but on that day, why you did not object? This court also observed that petitioner is permitted to array the, probably you submitted, you yourself have submitted, it appears, permitted to array the representatives of Hedu clan.
I pointed out also.
Okay, then I think.
My lord, if it is possible, then I filed the
think you have
affidavit
to
in the
include
additional
them. You have
later
to
on.
include- Because any order passed in this writ petition probably would adversely affect their interest. And that is why no order can be passed unless you implead them, implead the parties whom it's going to affect.
But my lord, regarding that this matter actually happened, this petitioner parties, the whole clan family members deciding that the stretch length of the Pumbung Relento suffer area. The respondent party police force and IRBN force took vacate the land forcefully. They illegally encroached the land and kick out them heavily. So every day, each and every way, then there's fear is life and their properties also. If the impugn is not stay, then they repeatedly do it every day. It's very tough. There is no home is there to stay anywhere.
What is your instruction?
Lordship,
You were also asked to obtain instruction.
yes.
Because some one person came my house and kick out me, and then how we're supposed to go, Your Honor? Their present scenario, they intentionally do me. So at least stay order reminding that this concerned authority, then we slowly and steady go to the exact point of
See, repeatedly you were asked to obtain instruction.
Lordship, regarding the instruction.
Well, where is the impugn order? Where is the
impugn order?
impugn order?
Yes, my lord. The impugn order is page number 25, annexure 6, my lord, in my petition. Last two paragraph.
Who passed this order? Deputy Commissioner.
Deputy Commissioner.
You are Hemi clan.
Yes.
Lordship may go through the whole order.
For halting of payment of compensation in respect of land stretched from. No, it's undisputed. Why you did not implead Hedu clan?
That's why from the beginning I have been.
See, no order can be passed. You first implead.
My lord, definitely I file in the before next date. At least give me impugn order regarding the some stay order, because the respondent party authority intensely.
You implead. You have no. See, you have to come clean hand. First of all, because any order passed here in this case is likely to adversely affect the other clan. That is why court will never pass such order in absence, because you have deliberately, it appears that you have deliberately avoided impleading them.
My lord.
Despite even asking them to implead also, because clearly mentioned in the impugn order, Hedu clan disputed between Hemi and Hedu clan.
My lord.
So under the circumstances, unless you implead, who will pass? Nobody will pass order, even if you cry also.
My lord.
See, court sees the balance, and if the court grants right or protect you, the court cannot, you see, pass anything against the other clan or other party. Court will also protect their right, give them an opportunity. Without giving an opportunity, how do we pass order? See, from it's very clear. That is why no order was passed. Had you impleaded them, probably you by now you would have enjoyed the interim order also.
Itself, it would have been.
See, from prima facie it appears from the order. That is why court disinclined to pass any order. When you are asked to implead, you implead.
My lord, may I see the annexure 8 Kohli, page number 28 to 31. It is some representation later regarding the entire fact and circumstance of the case.
Maybe that is not going to help. When the parties are involved, maybe this will be dismissed for non-implement of the necessary party also. If you fail to.
My lord, my just humbly prayer is that if there is no impugn order, okay, but at least give us some instruction. The respondent parties don't note anything, the said plot of land till the any disposal of the case, because they intentionally physically.
That order will be passed when you implead.
Yes, my lord.
Okay, Mr. Bagra, M. Bagra, Counsel for the petitioner. Stop. Miss Giete, Lana Additional Senior Government Advocate. Pray for Father. 1 week. We didn't see last occasion also. What are you doing?
But then there is nothing. They have only sent me their representation of the hearing.
Okay. Lana, Giete submits that although she has received an instruction, the same is incomplete. Therefore, pray for Father. 1 week time.
Lord, sir.
Hmm.
I don't know.
See the last. Have you seen the last order? Hmm? Have you seen the last order? The prayer for interim order shall be considered on the next date.
Yes.
Fairly informed about the instruction received by her in the matter. See,
I was not.
and because of your
Lord,
submission only, interim order was not considered. Hmm.
Lord, sir,
The prayer is allowed. List this matter after a week, 1 week. Okay.
My lord,
let the implement be done in the meantime, Lord, sir.
In the
We-
and if they don't do, he will face
consequences.
because order already there. Order is already there. In the meantime, you can file.
Definitely, assure, no time taken, but at least some protection given. Beauty.
What protection? It's going to affect the other community, other clan. No court will pass such order affecting the other person's right
But every day
in their absence. And see, even if you make whole the submission also, nobody will consider. I tell you, it is apparently clear from this order. Other clans are involved. You have not implemented them. Had you implemented, then is the order would have been passed earlier.
I have not had any.
Okay. Okay. Is it? What is this?
There was a supplementary you have already taken along with bill in the morning.
Okay.
Item number 1314.
Okay. It's done then.
Yes.